Good morning, everyone. VIRGOTRIAD here. It is April 4th, 2019. We are going to be talking about the real meaning behind common law. I am absolutely 100% sick and tired of the BS that is spewed regarding the supposed quote-unquote common law definition of people with the redemption theory, of the sovereign citizen movement persuasion, of the Moorish individuals. Let's talk directly about Anna von Reitz and her claim to fame with the BS that she talks with regards to common law. So today, I am going to actually give you the true meaning of what common law is. And I'm going to back that up with actual verifiable sources that you can look at and read for yourself. Now, interestingly enough, there will still be individuals that are not smart enough to recognize any kind of discernment when it comes to reality based facts versus a bunch of bullshit. But we're going to risk it anyway and give it a shot. So first, let's talk about what is common law. Common law is a body of unwritten laws based on legal precedents established by the courts. I hope everybody heard that well. It's a body of unwritten laws based on legal precedents established by the courts. Common law influences the decision-making process in unusual cases where the outcome cannot be determined based on existing statutes or written rules of law. Okay, so let's talk about that just for a second. Where the claim is that common law is for the people, in reality, common law is a body of laws that have never been written before. It's going to be based on case law. Based on laws, based on case law, meaning based on cases that judges have made determinations on that fit around the surrounding unusual scenario that's going on in that court case. So now it's the opinion of judges that we are basing this on, okay? So, common law to inform judicial decisions. A precedent known as stare decisis, a history of judicial decisions, which form the basis of evaluation for future cases. Common law, also known as case law, sound familiar, everyone? Relies on detailed records of similar situations and statutes because there is no official legal code which can apply to a case at hand. The judge presiding over the case determines which precedents apply to that particular case. The example set by higher courts is binding on cases tried in lower courts. This system promotes stability and consistency in the U.S. legal justice system. However, lower courts can choose to modify or deviate from precedent if they are outdated or if the current case is substantially different from the precedent case. Lower courts can also choose to overturn the precedent, but this rarely occurs. Now let's talk about some fast facts here. Fast fact number 1. Common law, also known as case law, is a body of unwritten laws that are based on legal precedent established by the courts. Fast fact number 2. Common law draws from institutionalized opinions and interpretations from judicial authorities and juries. You heard it right. Fast fact number 3. Common laws sometimes prove the inspiration for new legislation to be enacted. Let's talk about the difference, the real difference, between common law and civil law. Civil law is a comprehensive codified set of legal statutes created by legislators. A civil system clearly defines the cases that can be brought to court, the procedures for handling claims, and the punishment for an offense. Judicial authorities have the conditions in the applicable civil code to evaluate the facts of each case and make legislative decisions. While civil law is regularly updated, the goal of standardized codes is to create order and reduce biased systems in which laws are applied differently from case to case and defendant to defendant. Common law draws from institutionalized opinions and interpretations from judicial authorities and juries. Similar to civil law, the goal of common law is to establish consistent outcomes by applying the same standards of interpretation. In some instances, precedent depends on the case-by-case traditions of individual jurisdictions. As a result, elements of common law may differ among districts. Is everybody starting to get where these people are cherry-picking statements? See, common law is not just written in book form. Common law, actually, is law that is where previous cases that judges have decided on, their opinions are what are creating the common law. That is what is creating the common law. Not what you're being told is creating common law. Not the people. Judges. Okay? Judges in specific cases that create precedent for an unusual case. I hope that part of this is clear. Let's talk for a minute about how common law can marginalize certain groups. As judges present the precedents which apply to a case, they can significantly influence the criteria that a jury uses to interpret a case. Historically, the traditions of common law have led to unfair marginalization or empowerment of certain groups. Whether they are outed or biased, past decisions continue to shape future rulings until societal changes prompt a judicial body to overturn the precedent. All right, let me give you an example. So, until 1995, we didn't have all 50 states that actually had some form of law, real law, on the books about marital rape. If your husband raped you, it wasn't against the law. Do we want to go back to a time frame where judges made decisions based on other decisions that were made? Because this is a good example of where that happened to be the case. And it took until the mid-90s to actually get all 50 states. And Ohio is still questionable with regards to marital rape. Common law can very easily sway to one political side or another, to special interest groups, for example. You want to talk about things becoming unfair, let's go to common law, totally. You want to talk about things that can be prejudice against one group or another, let's go to common law. It makes virtually no sense what these individuals are saying, except for that they have an absolute agenda. Let's go ahead and talk about another little agenda here that helped with the ruling of common law. Feminists in the 19th and early 20th centuries who fought for women's rights, and we're not talking about today's feminists. We're talking about women who actually were just trying to get rights for women, like the right to vote, for example. Feminists who fought for women's rights often faced such difficulties. For example, in England, common law as late as the 1970s held that when couples divorced, automatically fathers were entitled to the custody of keeping their own children. It was a bias that affected all women and kept women trapped in abusive marriages because mothers were not even considered to be a custodial parent. The children automatically went to the father. Here's another real-life example of common law. From time to time, common law has furnished the basis for new legislation to be written. For example, the UK has long had a common law offense of outraging public decency. In the last decade, the authorities have used this ancient common law to prosecute a new intrusive activity called upskirting. The practice of sticking a camera in between a person's legs without their consent or knowledge to take a photo or video of their private parts for sexual gratification or to humiliate or to distress. In February of 2019, Parliament passed the Voyeurism Offences Act that officially makes upskirting a crime punishable by up to 2 years in prison and the possibility of placing a convicted individual on the sex offenders list. Prior to that, common law furnished the availability for it to be done, and it not actually be on the books as a coded offense. It took public outrage and to take all of those cases together in order to change that. It's amazing to me that anybody would actually try to push common law as being better than civil law. But what you have to remember is these individuals that are doing this, they have an absolute agenda. And their agenda is to bring down our system altogether. Bring down the entire government and court establishment and raise up their own kangaroo courts and make common law precedent so that this way they can have their kangaroo courts. And for anyone who speaks out against them or their kangaroo courts or their scams that they try to claim, they can simply hang them without a jury. They can simply hang them without a trial. They can do whatever they choose. I don't think people honestly realize the damage that what is being claimed can do. Alt-right and alt-left groups always have had their fingers in the pie when it comes to attempting to try to push common law as being a real thing that could happen in the United States. It could, but now we're talking about using opinions versus a set standard. Opinions of one person a lot of times. I think everybody needs to think about this, and I think everybody needs to investigate a little bit more. The links that you can use to investigate common law are going to be in the description of this video. And I hope this has helped everybody to understand a little better what common law really is. Common law is not what everyone in a democracy voted on. Common law quite often comes from the judicial decision of one entity, the judge. It's not necessarily something that's understood by the public. It's something that was meant to be used as precedent for a case which was maybe unusual in comparison to what we would find in a regular court case. All right, everyone, have a great day. Bye-bye.